for this morning's online panel discussion event. We're delighted to be holding the session in collaboration with our benefactor member, Stevens & Bolton, which is a full-service law firm with extensive experience in advising companies from Spain and elsewhere on establishing a presence in the UK. This morning's session will cover a variety of topics relevant to SMEs and entrepreneurial businesses navigating the circumstances that we all currently find ourselves in. Please remember that this will be an interactive session, so please do feel free to write in any questions that you have using the Q&A tool or the chat feature that you'll see on the bottom of your screen at any time. There'll also be time for any further questions to be asked to the panelists at the end of the discussion as well. I'm now going to hand over to Nick Atkins, who is a corporate partner and head of entrepreneurs at the firm, who will introduce our panelists and be the moderator of this morning's event.
Good morning, and thank you very much, Hannah, and to the Chamber for hosting us today. SMEs and entrepreneurial businesses form the backbone of the UK economy, representing just over half of turnover in the UK private sector at approximately £2.2 trillion. They're some of the most agile and innovative businesses in the UK, and they employ 3/5 of UK employment. Last week, here at the Spanish Chamber of Commerce, we had the honour of hearing from Mike Cherry, Chair of the Federation of Small Businesses, and we listened with interest to the pressures felt by small and medium-sized enterprises in the UK. Speaking with SMEs, we hear stories of significant pressure on cash flows resulting from the economic shock of lockdown, customers delaying payment, and the disruption caused by social distancing and the public health crisis. With the statistics I just quoted and the pressures faced by businesses, it has been paramount that the government respond with schemes and initiatives to mitigate the depth of this impact. Today's session is therefore here to summarise and signpost the key schemes in place to alleviate that impact and hopefully to help SMEs bounce back from this crisis. Now, we have a short window for this webinar and a lot of ground to cover. The format of this webinar, as Hannah said, is a panel discussion between me and 5 expert colleagues who I will introduce shortly. The Q&A function on Zoom is live, so please feel free to share your questions with us as we go along. We will do our best to pick them up during or at the end of the session. If you have a burning question we do not have time to answer, please do get in touch with us afterwards. We have divided our webinar into 3 main areas: cash and liquidity, which frankly is the overriding theme throughout, as this is the primary economic effect of this crisis; premises, which of course is a substantial overhead for a lot of SMEs; people is our third topic, which is another overhead, but also part of the human dynamic of this crisis. On your screens, you can see 6 faces. There's me, Nick Atkins, corporate partner and head of our entrepreneurs group. And I'll now pass you on to each of the people in turn, starting with you, David.
Good morning, everyone. My name is David Steinberg. I'm a partner and co-head of our restructuring and insolvency practice at S&B, and I've been very busy since March on advising corporate clients and lenders on the issues arising related to solvency out of the COVID-19 pandemic.
Boma?
Yep. Hi, my name is Boma Adoki. I'm an associate in the Employment, Pensions and Immigration Department, and I specialise in the employment side of things. As with David, I've been very busy lately, especially focusing on the furlough scheme and basically looking at employment aspects of the current crisis.
Thanks. And Helen?
Hi everyone. So I head the real estate disputes team at S&B. We've been very busy, as others have said, the last couple of months on lots of landlord and tenant issues coming out of the lockdown, premises and insolvency issues.
Thanks. And Kerry? You're on mute, Kerry.
Good start. Morning. Hi, I'm Kerry Garcia. I head up the employment and immigration team and have been busy on a mix of employment work in relation to COVID, similar to Boma, and also dealing with the immigration fallout with borders closed and all the chaos that has caused.
And over to you, Nassar.
Hi, good morning, everyone. My name is Nassar, and I'm a senior associate in the firm's corporate team. I advise on a range of corporate transactional matters, including M&A, venture capital, investments, and private equity-backed transactions. And I'm also part of the firm's entrepreneurs team.
That's great. Thank you all. So, as I said, a key challenge of the current crisis is cash. Cash is king, and short-term shortfalls can push a usually sustainable business to the edge. So David, imagine I'm a director of an SME, and like many SMEs at the moment, I'm looking to manage my company's outgoings. Is COVID-19 a legal justification for not paying suppliers?
Short answer is no, it's not a legal justification. One should always check one's contract first, just to see if there's a surprise there for you which might assist you in arguing that you're not obliged to pay. We have checked things like force majeure and frustration provisions to see if that gives debtors an opportunity to legitimately withhold payment from creditors, but it is very, very unusual for such provisions to be available in a situation such as this. So the general principle is subject to issues on insolvency law reform that will come up with, that it is not a legitimate reason for not paying a creditor.
And taking that another step forward, David, if one of those creditors who's unpaid then threatens to serve a statutory demand or a winding up petition, what do I do then as a director of that SME? Right.
Well, this is an issue which I'm sure a lot of the people listening in today will be aware of this themselves from their own experience in business, but it has been a very live issue, particularly in relation to commercial tenancies since the pandemic started, because a number of landlords in particular, but not just landlords, who were not paid when the March quarterly rental payments were suspended by a large number of retailers in particular, have been pressing hard for payment, and in that connection have been presenting statutory demands and threatening to commence winding up proceedings. Now, the current position still is that landlords are entitled to do that, other creditors are entitled to do that, and if the retailer or whoever it is, the debtor, does not pay, then on the face of it, the creditor is entitled to then proceed to present a winding up petition. Now, back in April, the government intended to introduce new legislation to deal with that problem, recognising that it was a particularly critical issue for those retailers who have had to shutter their premises. And there was a bill published finally yesterday by the government. It's not yet law, so it's still just a bill, but that sets out the promised relief which the government intends to make available to debtors in that situation, which essentially will prevent the court from making winding up orders based upon statutory demands presented since the 1st of March, up to and including the end of June. There is an opportunity for the government to then extend that period, but right now that is the sort of the safe harbour period. So for debtors who have not yet been the subject of winding up proceedings, and some have, that will provide them with relief, assuming that it goes through on that basis.
That's great. And amongst those trade creditors, would it be acceptable to prioritise some critical trade creditors over others?
I think that is right, yes. I mean, it is a debate we have a lot with corporate clients who are in financial distress, who don't have sufficient financial resources to pay all their creditors, who for one reason or another are not able to plug the gap with one or other of the government funding schemes that's available. And they find themselves in a situation where they can't afford to pay everyone, where they are still trying to secure the survival of their business as a going concern. And in order to do so, they want to pay those who they regard as critical or core creditors and not pay the non-core creditors for the time being and try to fend them off. Now, one of the concerns which directors express is whether if they do pay the core creditors but not the non-core creditors, whether that could get them into trouble either on the basis of wrongful trading under English insolvency legislation, or indeed on the grounds of unfair preference. Now, with respect to wrongful trading, again, help is at hand. The new insolvency bill that was published yesterday, as indicated by the government in its prior announcements, does give relief to directors from possible exposure to wrongful trading liability for basically any financial deterioration which occurred during the pandemic period, so long as it was attributable to the pandemic. In relation to preferences, I think our advice to directors in that situation has always been that where they are trying to secure the survival of the company, and they conclude in their reasonable judgment that in order to do that, in order to maximize the prospects of securing the survival of the company, they need to keep their core creditors, their critical suppliers happy and supportive of the business. If that means they make a payment to them and not to others who are less critical at that time, that is not an infringement of insolvency laws. So the directors should not be exposed to any personal liability for doing that.
That's helpful. You mentioned wrongful trading and the recent changes were hot off the press yesterday, the changes that have been published by the government. Reggie James has just put in a question saying that the recent initiative by the government regarding wrongful trading, is that not only delaying the inevitable until after June?
It rather depends on what the inevitable is, I think, but it's a very legitimate question. I mean, I think there are a number of businesses, I think particularly in those more distressed retail sectors who are not just very badly affected by the current pandemic, but are also envisaging that because of the slowness with which lockdown will be lifted, certainly insofar as their businesses are concerned, that it may well be their businesses are just not going to be able to survive. And I think if the inevitable means will they have to file for insolvency, then I suspect these laws will not prevent that. They can't defy gravity. So I think Reggie's right. I think the reality is unless there is a solution in sight, which enables these businesses to conclude that they can, after all, survive in the longer term, even with extended pandemic and lockdown provisions, they will need to file for insolvency. But what it does mean is that these rules on wrongful trading at least mean that during this period they are in a safe harbour period, so they're not forced to make that judgment call now.
That's great, thank you, David. Now, Nassar, staying on the subject of cash, the government has moved into new ground by announcing the Future Fund, which was just opened yesterday for applications. Can you tell us what it is, who can access it, and why it's new ground, please?
Nick, yeah, that's right. On Monday, the government finally announced further details on its Future Fund, which is a government-backed scheme aimed at supporting high-growth companies during this period of disruption and liquidity squeeze. Now, the government is initially contributing £250 million towards the fund, but the government confirmed that once it's been deployed, the fund may be replenished. And as you mentioned, the scheme opened officially for applications yesterday and is intended to run up until September 2020. Now, it was introduced to plug a perceived gap in coverage for startups and scale-ups in the UK in some of the government's package of COVID-19 liquidity schemes, such as the C-bills, which some of you may be familiar with. Now, this is because most high-growth companies are unlikely to satisfy the eligibility criteria set out in some of these schemes, or they're being denied funding from banks delivering C-bills because the government is only offering a partial guarantee against loans advanced under that scheme. The Future Fund will be delivered in the form of a convertible loan, ranging from £125,000 up to £5 million per company, and is intended to be rolled out by the government as a co-investment financing round, with match investing on a pound-for-pound basis by private sector money, such as venture capital funds. Now, the fund is designed to address liquidity concerns in companies that have already raised funding from the private sector by facilitating and encouraging follow-on funding, rather than act as a scheme to inject startup capital in new companies. So in order for a company to be eligible to access the scheme, it must, among other things, be registered and based in the UK and have raised at least £250,000 in equity from third-party investors in the last 5 years.
Thanks, Nassar. You mentioned there that the government would make the investment by way of a convertible loan rather than subscribe for shares on day one. Why do you think they've gone with that route?
Yeah, I think it's because of the nature and the key features of convertible loans, which makes them relatively quick to implement with minimum paperwork. Now, convertible loans are financing instruments which could be either repaid by the borrower company on a set maturity date, or converted into shares in the company on the occurrence of a conversion trigger event, for example, a future equity funding round. Convertible loans, they're generally seen as investor-friendly financing instruments because of debt investment is seen as a less risky investment than a pure equity investment. And that's because the amount invested could be repaid after, rather than converted to equity in a private company, which is an illiquid investment. And the convertible loan will usually attract an interest rate, which is another upside for an investor because it will increase the return on investment, which won't be the case if you do a pure equity investment. From the company's perspective, one of the key differences between a convertible loan and equity investment is that if a company raises cash via equity, it'll have a positive balance sheet. However, if the company raises cash via convertible loan, the company will have cash, but it'll also have increased its debt obligations on its balance sheet. So from the company's perspective, care needs to be taken to ensure that its debt obligations don't become greater than its assets. And one of the benefits of investing by way of a convertible loan is removing the need to agree about a company valuation at the date the investment is made, as the valuation is typically agreed on a future funding round. Valuing private companies, it's a pretty tricky task in normal times, and it can usually take quite a bit of time and negotiation between investors and companies to agree a valuation that both sides are happy with. And with the backdrop of the COVID-19 pandemic, it's become increasingly difficult for investors and companies to agree valuations with financial projection metrics and comparables that they typically use cast into doubt. In terms of the minimum key terms that the government is willing to invest on following the future fund, these include that the loan will be unsecured, which is good news for the company because it will avoid having to deal with intercreditor and subordination arrangements. The company has existing security. The loan cannot be used to repay any shareholder or founder loans or pay any dividends. And this restriction makes sense to us because the funds should be used for working capital purposes to ease any immediate liquidity concerns. The loan will mature after 3 years and it'll attract an interest at a minimum rate of 8%, which will be rolled up and repaid on maturity or when the loan converts into equity. And this rate of interest of 8% is around the average rate we see in these types of growth capital investments. Now, if there's a conversion trigger event, such as a future funding round, the loan will convert into equity at a minimum conversion discount of 20% to the price set by that funding round. And the range of discounts we typically see in the market are between 10% to 30%, with 20% being the most common. Now, a potential sticking point is that if the loan isn't converted into equity, it'll be repaid by the company on a maturity date with a redemption premium equal to 100% of the principal amount invested. What that means is effectively it's netting the government and the investors a 2 times return on their investment. This is a pretty investor-friendly position, and it could cause some companies to think twice before accessing the scheme. But on balance, we think the terms on which the government is proposing to invest are fairly neutral for both the investors and investee companies.
Thanks, Nazar. On well, a broad question for you, which I hope you don't mind. What do you see as the initial main issues with the way the Future Fund has been structured? We've read quite a lot in the press over the last few weeks since it was first announced. Quite a few complaints about its compatibility with certain tax efficient schemes, etc. Do you have any thoughts on that?
Yeah, that's right. I mean, the Future Fund it will benefit companies that are more in the mid to late stage of their growth cycle, but the primary concern would be around the early stage part of the VC market. And that's because the early stage pre-revenue companies, they typically raise funds from angel investors, early stage funds, venture capital trusts that typically invest on the basis of access to EIS and SCIS tax reliefs. And these are government schemes which can give huge tax advantages to individuals or funds investing in startups. Now, the challenge of the Future Fund investment terms is the matched funding requirement. In other words, the investors in the private sector, they have to invest on the same terms as the government. Now, the problem with that is that the investment requires the use of a convertible loan instrument, which is non-EIS eligible because of its debt-like features. Now, EIS investments, they're usually done as equity investments, which are day one share subscriptions. So the requirement to use the loan will be problematic to an investor seeking EIS tax relief because the shares will be issued to the investor at a later date. The 3-year time maturity period and the 100% redemption premium are also problematic for any venture capital trust looking to participate in the scheme. Another issue that may affect certain companies is the requirement that the applicant company must be based in the UK, which might exclude startups that operate in the UK but are backed by overseas accelerator programs, which tend to have parent companies incorporated in these overseas jurisdictions. With more than half of the funding of UK startups coming from angel investors and family offices, the incompatibility of the future fund with EIS tax reliefs can be viewed as a real gap in its design. But we think there are other considerations at play here. First, we understand that there were discussions on a rule of change to allow the convertible loan, or at least those specifically used for the future fund scheme, to attract EIS relief, but it was concluded by the lawyers that such a change would violate EU state aid rules. And second, the exclusion of the angel investors and friends and family looking for EIS treatment might mean that the government will end up investing in companies that have been diligenced and vetted by professional investors, with potentially better outcomes for the UK taxpayer. Another reason could be that angel investors and early stage funds and VCTs, they already benefit from availability of government-backed schemes such as EIS. So they don't really need further encouragement or support to invest in UK startups and scale-ups.
Thanks, Nassar. And David, of course, we've talked about cash flow issues and the possibility of equity funding through the Future Fund. And Nassar briefly mentioned CBILS there, which is the Coronavirus Business Interruption Loan Scheme. Both CBILS and its junior sibling Bounce Back Loans have been in operation for some time now. But please, could you briefly remind us of those schemes?
Yes, of course, Nick. The CBILS scheme, which stands for Coronavirus Business Interruption Loan Scheme, was introduced by the government quite early on in order to provide liquidity to SMEs. And the basis of it was that it would be provided via banks, via commercial lenders who would be accredited to provide those facilities. It would benefit from an 80% guarantee from the government. Now, the 80%, a number of points to make here. First of all, the 80% guarantee is for the benefit of the bank, the lender. So in other words, if the borrower doesn't pay the bank at the end of the facility, then the lender can turn around to the government and collect 80% of the principal only, not the interest, from the government. So the lender still has to bear the exposure on the balance, the 20% of the principal plus any interest. It was initially made available to SMEs with turnover of up to 45 million, maximum amount of £5 million. Most of the commercial terms, however, it was left to the lender concerned to set. So, for example, the interest rate, any fees, that was for negotiation between the borrower and the bank. Ditto with personal guarantees. And of course, as we know, that caused quite a lot of fuss in the earlier stages of the programme, where lenders were seeking pretty comprehensive security packages as well as personal guarantees from the founders in order to make these facilities available. That caused a lot of anguish on the part of the borrowers, really for a couple of reasons. First of all, because it was just taking too long to put those facilities in place, a lot of process involved. And secondly, of course, they were then being asked to take personal exposure under the personal guarantees. So that was tweaked by the government so that now under CBILS, if the loan is for 250,000 or less, then the founders cannot be asked to give personal guarantees. The CBILS facility is quite a flexible facility in the sense that it can be an overdraft, it can be a term loan, it can be an invoice discounting facility or an asset financing facility. The term, it goes out for up to 6 years, and there is a 12-month payment holiday. The first 12 months, there is a payment holiday in respect of interest and any bank fees that are payable, like commitment fees, facility fees, etc., for setting the facility up. But the key problem with it was really the 80%, because the result of that was that the banks clearly had skin in the game, which initially was considered a good thing, But of course, it meant that the whole thing was slowed down. The process became very slow. Banks took a view on the risk that they are prepared to incur. Now, the bounce back loan scheme was therefore introduced as an alternative. It's simpler. The key difference is that the bounce back loan, there is 100% government guarantee, so covering the whole of the principal plus the whole of the interest. That has an important effect, of course, because the bank then doesn't need to, if you like, assess the credit worthiness of the borrower in the same way, because they are fully covered. There are no fees payable to the banks, which is what you would expect because it's zero risk for them. The interest rate, which in the CBILS facility would be a matter for negotiation between the lender and the borrower, and again was the subject of a lot of contention as a result of the very high interest rates that the banks were asking for in some cases. Under the bounce back loan, it's fixed at 2.5%. No personal guarantees can be asked for, and again, it's for a 6-year term. It's a less flexible form of financing than CBILS in the sense that you can only have term loans. So in other words, you're not allowed to have an overdraft facility. Those cannot be made available through the bank bounce back loan scheme. I think the key point, though, to bear in mind, it's very important for borrowers, is that whether they go down the CBILS route or whether they go down the bounce back loan route, they are liable for the loan. And at the end of the term, they have to repay. And if the government pays out on the guarantee, that's great for the lender, but they still have to pay. It will be interesting to see post-pandemic how those indebtedness obligations are worked out as between those borrowers and the government, who will clearly step into the shoes of the lender once it's paid out under its 100% guarantee. How that restructuring of those loans it plays out. I suspect we'll be watching that with interest in this profession.
Thanks, David. And that's a very good point, a very good reminder that although there are lots of grants out there and R&D grants being made alongside the Future Fund, for example, the CBILS loans and the bounce back loans are real debt. It is going on someone's balance sheet as debt. But it's been pleasing to see access to that debt finance through CBILS and bounce back has increased greatly recently. It's turned a real corner. We heard from Nadeem Zahawi, MP, Minister for Business and Industry, just here on the Spanish Chamber on Tuesday this week. And he was reporting that there's now been £5.5 billion worth of finance through CBILS alone. And that lending through that scheme increased by 1/3 just last week. So that is a promising sign, hopefully, of liquidity being injected into the market. Now, on that subject of cash flow and liquidity, as I said at the very beginning of this webinar, one area of impact of tight cash flow is on the ability for companies to pay overheads. And for many companies, one of the largest overheads is bricks and mortar, the cost of rental of its premises. Helen, what are an SME's options when it can't pay its rent or wishes to reduce its present expenditure on premises?
Right. Hi, Nick. Yes, as a starting point, really, as David said, is to check carefully what your documents say. Are there any provisions for getting out of them in these current circumstances? Now, on that, I would say it's unlikely to be the case that there are any COVID-related get-outs for your businesses, which would mean that you're either not liable for the rent or that you can otherwise walk away completely. We've been looking a lot at this on frustration, force majeure, arguments around suspension of rent during lockdown. And really none of them have legs, so it's not going to help you, unfortunately. So look closely at your lease, your serviced office agreement or license, whatever you have. Think about what premises your business is likely to need, not just now during lockdown, but in the short and medium term future, before you rush to terminate any agreements that you can get out of. It can be very expensive, both in time and management cost and hard cost to move premises, relocate, and then go back in and have to have a fit out cost again. But that said, if your lease or other agreement is coming to an end soon and you want to stay, do make sure there's nothing you need to do to preserve that right to stay. Or alternatively, if you need to get out, that there's nothing you need to do to make sure you've served notice to bring that to an end. On that, keeping an eye on dates is really important. If you have to give notice to exit your premises, either as a break clause in a lease or notice to terminate some serviced office agreement, don't miss the date. Often these are once and for all dates that aren't rolling. So if you've missed it, you could be tied in, say, on a commercial lease for another 5 years, which is just space and overhead you don't need and want. On a serviced office agreement, for example, it might be roll into another 12-month period. And again, that's just dead cost for space you can't use and the business doesn't need. Make sure you give any notices properly. Just sending an email to your landlord or the agent that you've been dealing with probably won't be valid notice under most property agreements. But otherwise, if you have a standard commercial lease, usually that will allow assignment or subletting of your space, but it will be subject to landlord's consent and usually quite a lot of conditions in the lease on that. If you want to share space and just think you can get another similar sized business in to offset some of your rental and other costs, do check carefully, because usually that isn't allowed under the lease. But bear in mind that if you are applying to your landlord to try and assign or sublet, there's unlikely to be much appetite out there. There's going to be potentially a lot of surplus commercial property space, as we've all got used to working remotely this last couple of months. And I think businesses of all sizes are reviewing their premises needs quite generally. You may, of course, be able to agree a temporary rent concession with your landlord for the rent that's owed, or a more general renegotiation or re-gear of your lease commitments. So that might involve extending the lease by any period of rent-free that's agreed, dropping a break clause that will obviously benefit the landlord because it has you tied in for longer, or perhaps having to put up a guarantor to get some short-term rent relief. But do take advice, because it's going to be important that you don't give away too much for short-term rent relief that may be outweighed by what you sign up for in return. Ultimately, if you don't or can't pay your rent, landlords usually have a right to forfeit or terminate your agreement. However, currently there's restrictions in place under the government's Emergency Coronavirus Act that was introduced at the end of March, and that stops landlords forfeiting commercial leases for non-payment of rent. Now, currently that runs until the end of June, and we're keeping a close eye on whether that's likely to be extended. Now, as a business, you might be relaxed about the prospect of your lease being forfeited, as it would bring your liabilities to an end, more or less. But of course, in the current market, it would be an unusual landlord that would do that, as they wouldn't have you on the hook anymore for rent, and they'd be unlikely potentially to fill that gap, and they'd also have liability for business rates. So I think see what you can get in terms of concessions with your landlord, and look closely at your documents to see if you can give notice to get out of any agreements.
Thanks, Ellen. And thinking about the sort of here and now, for a lot of SMEs, the next quarter's rent falls due on the 24th of June, which is just a few weeks away, really. What should companies be thinking about now if they don't think they'll be able to pay the rent?
Yes, that's right. It's now just under 5 weeks, unbelievably, until the next quarter rent falls due, and that's going to be very unwelcome for many businesses up and down the country. As you say, absolutely, get in touch with your landlord is the best thing to be doing right now if you haven't already. So if you haven't already had those discussions around the March quarter and agreeing some sort of rent concession, monthly rents or reductions or deferments over the rest of the term, see what you can find out and what you can propose to the landlord and what they might agree. Before agreeing anything, of course, landlords are likely to want to know what your business's financial position is, and particularly whether you've accessed any of the government funding schemes that David and Nassar have touched on. You know, they may want to know that you're making an effort rather than them just giving away otherwise rent that they're entitled to. So you should expect your landlords to want to see some sort of cash projections, possibly management accounts, while it's deciding whether to help out or not. But in the current circumstances, like many landlords are being much more collaborative, much more commercial, and they're not insisting on their strict legal rights, because it's in their interest as well that all of these businesses that are the tenants of commercial space up and down the country, that they survive and they're not left with voids and, as I say, liability for business rates if companies go under and walk away from their premises through insolvency means. So, you know, talk to your landlord, have a plan of what you're proposing, have something to back it up with, and really see if you can agree anything. Touching on forfeiture again, if the current restrictions do come to an end at the end of June and you haven't paid either your March or your June rent or both, and landlords are able to forfeit, although that would seem unlikely commercially at this stage, you might want to think in practical terms about getting anything out of your premises if you left them pretty quickly once the government announced the lockdown on the 23rd of March. So if there's anything you need that you haven't yet retrieved from your premises space and it's safe to do so in line with government guidance, come the end of June, you may want to be thinking about that in practical terms.
Thanks, Helen. And Boma, just Helen there mentioned the lockdown and people obviously working remotely. With the move from the stay-at-home mantra to stay alert, many SMEs will be looking at returning to their premises quite soon, particularly those where remote working isn't a realistic option. What do employers need to consider in respect of their duties to their employees when returning to their premises?
Yeah, thanks, Nick. And I think just firstly, it's important to look at the legal position here when we're talking about this shift from stay at home to stay alert. You mentioned where it might not be realistic to work at home, but the legal position is that it's still the case that employees mustn't be going to work if it is reasonably possible for them to work from home. So just to make that point, that in terms of following what the legal position is, employees mustn't be sending employees to work if it's reasonably possible for them to work from home. So if they have already to this point had a workforce that is based at home, then they should stay there if they can carry on doing their job there. But as you say, for those businesses where people can't work from home and where obviously they're starting to be able to open, I would flag just, I think, 3 key areas for employers to be thinking about. Obviously, we don't have time to go into them in detail here, but just to signpost 3 key areas to think when we're looking at this gradual return to work. And those are health and safety, data protection, and then equality and diversity considerations. So firstly, with the health and safety point, as I'm sure most employers will know, employers do have a legal duty to take reasonable care of the health and safety of their employees. And a part of their duty, they do have to take reasonable steps to provide a safe place of work and a safe system of work for their employees. And in line and in parallel with this this established legal position, the government has actually also set out guidance for employers to follow in their return to work plan. So employers should in every case be referring to this and following the information set out there when they're planning a return to the office. And just to pick out a couple of key points from there, as part of their health and safety duties, what employers should be doing in line with the government's guidelines is to carry out a COVID-19 risk assessment. And in doing that, they should be identifying risks in the workplace. And it should also be taking into account different groups of workers, for example, vulnerable workers, in respect of whom they'd need to take extra health and safety measures. And a bit more on that in a minute. But of course, it goes without saying that there's no one size fits all here. Obviously, the risk assessment and its outcomes will depend on the workforce, the workplace, and also the nature of the business as well. And then once the risk assessments have been carried out, then of course employers need to set up and implement measures to minimize those risks. And any measures should always be in consultation with the employees that they're actually being brought into place for. So they should open up those lines of dialogue and make sure employees are being consulted. And then just to flag as well that the guidance does also recommend that employers actually share the results of their risk assessment. It could be just by publishing it on their website. And for businesses with over 50 employees, that is the expectation from the government that they should be sharing. So that's just something to bear in mind as well. And just also in terms of the office space, Helen's talked about different kinds of agreements, and in terms of practical steps for implementing measures, it might be that landlords and office managers and different parties would be involved in actually implementing measures, depending on what kind of office space you're using. Maybe it's a flexible office or you're renting space, but it's important to remember in terms of the health and safety duties to employees, that always falls with the employer, and the employer has that responsibility. And then just quickly on data protection as well, this is likely to be another consideration when employees come back to work, and particularly if employers are collecting more personal data on their employees to make the necessary risk assessments, adjustments, etc. So employers may already be aware of certain information of their employees. For example, they may well already know if an employee is pregnant or if they have a disability, but they might also be collecting additional personal data that they didn't have before. I'm thinking in particular, for example, if employers are thinking of bringing in workplace testing, then they would be collecting data they don't have before. And of course, in any situation where employers are collecting a new type of personal data, or they're changing the purposes that they're using the personal data for, they should be updating their privacy notice and making sure that's circulated to employees so they know what their personal data is being used for and collected, and how it's being collected, etc. And then just a last one on equality at work. And so when applying these government guidelines and implementing their return to work plans, employers should remember that their duty not to discriminate against any employees also applies in these circumstances. So employees might have a particular protected characteristic that could result in them being discriminated against, such as age or sex. And it's worth remembering that employers do have a particular responsibility towards, for example, disabled workers or new and expectant mothers. So, for example, with disabled employers, they may be under an obligation in certain circumstances to make reasonable adjustments in respect to the employees. And employers must also ensure that any steps taken don't have, for example, an indirect negative impact on certain groups. So there may be people with caring responsibilities who are impacted more than others, or people with certain religious commitments. And those are things to think about as well. But it is worth noting that generally, when we have this legal framework, a lot of it, especially in terms of health and safety and discrimination, these are established legal frameworks. They were drafted before, they've been established before. They weren't put in place with the COVID-19 crisis in mind. And because of that, what we're trying to do at the moment is applying a regime that wasn't tailored for the pandemic. So obviously we're not living in an ideal world, unfortunately. So it is likely that we'll probably see application of this varying between employers, and it might be a bit of a case of hit and miss. And so we probably will see certain points in this coming up in litigation. And because of this, that makes it all the more important for employers to ensure that they're familiarising themselves with and following the government guidelines and keeping to that guidance wherever possible.
Thanks, Boma. Helen, one question we have, which is beyond sort of the employment aspects, but bearing in mind the planned return for some businesses to work, or the fact that some businesses are currently planning their potential return to work, do businesses have any additional obligations in respect of their premises for their staff and visitors?
Yes, the obvious thing to mention here is occupiers liability. So generally a business will be an occupier of whatever space it has, and will have a duty to take reasonable care to ensure the safety of visitors. Now, the question of what's reasonable will be different in each case, but compliance with government guidance that's issued from time to time and keeping up to date with that will stand you in good stead of meeting and discharging that duty. A lot of the practical measures involved will probably mirror the issues Boma has flagged on employment and health and safety. So there shouldn't be too much onerous extra steps to take. So if you're following the guidance on social distancing, on providing hand sanitation, for infection control, limits on numbers and staggered returns to offices, for example, that should go some way towards meeting it. But it will be case by case. It will depend on particular circumstances. It's worth mentioning, if you are yourself also a landlord, or you're responsible for some common areas or shared areas like receptions and lobbies, as landlord, you'll also have similar duties to take reasonable care and reasonable steps to ensure that anyone visiting the building isn't exposed to any risks to their health. So there'll be very practical things that have to be worked through for each particular physical layout of the premises and the buildings that are involved. There's a lot of guidance being issued, so it will be important to keep on top of that as it comes out.
Great, thanks, Helen. And talking about people, the impact of tight or negative cash flows on companies is that they naturally look to reduce their overheads, which is a key feature of which is their staffing cost. To mitigate the shock for the economy and households, the government has put in place the job retention scheme, which enables the temporary furloughing of employees whilst retaining their jobs. Now, Boma, back to you. On this topic, please could you give us an update on the furlough scheme and the recent announcement from the Chancellor on it?
Yeah, so as I'm sure everyone or most people here knows, the scheme was brought into place with effect from the 1st of March, and it was initially set to run until the end of June. And under that scheme, currently and since it started, employers can claim a grant for wage costs of employees, and that covers 80% of their monthly wages, up to a cap of £2,500 a month. So as you mentioned, there's been an update to that. So on Tuesday last week, the Chancellor announced that the scheme would be extended now until the end of October, although there will be some changes there. So the scheme will carry on in its current form until the end of July, and employers can continue to use the scheme at any time during the period. But from August onwards, the announcement has said that employees currently using the scheme will have more flexibility to bring furloughed employees back to work part-time while still receiving support from the scheme. At the moment, we are just at the stage of the announcement, so we don't have the full details of how this new phase will work and what the finer points of that are. But key points to note on that at this stage are, firstly, that under this new phase, employers will be asked to pay a percentage towards the salaries of furloughed staff. So what they'll be doing is essentially picking up some of the cost burden that the government's carrying at the moment. Although at the moment it's not yet clear how much employers will be required to contribute, and whether that might actually affect different employers in different ways, whether there are different levels of contribution. And also another point to be aware of is that the provision of part-time working is quite a key change. At the moment, furloughed employees can't work at all for their employers, so that's quite a change there. And I think that change to allow for some part-time working does kind of reflect that shift that we've seen in the government guidance in respect to the furlough scheme, whereas previously the focus was on that the saving the jobs and the keeping the jobs in place. There's now also mention and focus on protecting the economy, and I think we see that in the government gradually getting the gears moving by allowing some part-time working. And just a final point to flag on that, it's not clear, but the wording of the press announcement does make it seem as though the extension of the furlough scheme from August to October may just be open for employers who've already taken advantage of it up to August, where it's still in place in its current form. But more on this and the rest of the scheme later. So watch this space at this stage.
Thanks, Bomber. Now, the UK economy is, of course, dependent on a large number of workers coming into the labour market from outside the UK. And with COVID-19, we've probably all forgotten about Brexit, but it is there, and the implementation period comes to an end at the end of this year. Kerry, on the immigration front, I suspect a number of people listening to this today work in businesses which employ European nationals. How does COVID-19 impact them and their right to come to the UK or to stay in the UK? You there, Kerry? I think we might have lost Kerry. So let's just see if we've got any other questions coming through in Q&A while we wait and see if Kerry springs back to life. So B, back to you. One question we have is that, are there other alternatives to the furlough scheme for employers if there is insufficient work for their employees, or if employers do not have enough cash to pay all their employees?
Yeah, so there are a few potential alternatives. What they would generally involve would be some changes to the way in which their employees are working. So firstly, if they haven't thought about this already, it may be a point to think about potential pay cuts for the workforce. Of course, this is something that would need the employee's consent and should be kept under review. But a potential pay cut of a certain amount is something that could be thought about. Another one is a potential reduction in working hours. This is, again, something that would need to be done with employees' consent. And would of course be dependent on the needs of the business. But if there is scope for that, then a reduction in working hours may also be a way of reducing costs. Of course, with the potential for furloughed employees to be able to work part-time, that might have a play in how you could work that, but that's another potential option. And then if there are any bonus schemes in place, any discretionary bonuses, then considering suspending or delaying those for the time being is another potential way of cutting costs there. But if other cost-saving measures aren't enough, then unfortunately, and I think this is a phase that a lot of employers are starting to think about now, then redundancy may need to be considered. And as part of the redundancy consultation process, of course, employers should be considering, together with the affected employees, whether there are any ways in which the redundancy could be avoided. So employers should be prepared to hear suggestions from the employees themselves on how they think that the redundancy could be avoided and cost saving measures could be brought in. And in any of these things where it does involve a change of the terms of the employees, as I mentioned, just to stress, that would need to be with the employees' agreement. So as with the other points, it's always important to keep the employees in the loop, as it were, and keep those lines of dialogue open.
Thanks, Boma. That's really helpful, and is indicative of some of the challenges ahead, I think, for the economy over the next few months, and for a lot of SMEs listening to this. Kerry, I don't know if you heard my question. I thought you were doing a very good impression of being frozen, but then I realised that your screen was actually frozen. Looks like you're back to life now. My question was, I was commenting on how we have the sort of the double whammy of Brexit alongside COVID-19, and Brexit being the kind of lesser, the one that's been forgotten effectively in the midst of all this. And a lot of people listening to this webinar may employ European nationals, and the question was how COVID-19 impacts them and their right to come to the UK, or in fact to stay in the UK.
Yeah, thanks, Nick. No, absolutely. Just to mention that COVID-19 has obviously had a big impact on immigration generally. So particularly if you happen to be a business which sponsors tier 2 nationals, tier 2 employees, and you're sponsored under that regime, then definitely I would get some advice if you're considering furloughing them, or if there are any changes where you want to sponsor somebody. But in relation to European nationals, there haven't been quite such drastic changes. At the moment, they can still come in freely to the country as long as there's commercial flights operating. We haven't introduced quarantine yet, although that's definitely something to keep an eye on. It's likely we're going to end up with 14-day quarantine periods for most people entering the UK. So that would affect most European nationals as well, we suspect. But the big thing to bear in mind is that the government has made it very clear they're not planning on changing the current implementation or transitional period following Brexit. So what that means if you employ European nationals is free movement still is due to end on the 31st of December this year. So for the moment, they can come in, they can work, but after the 31st of December, anybody who wants to come in from Europe is going to have to qualify under immigration rules. If you've got existing European workers, it's worth reminding them they still need to apply for the EU settlement status under the EU settlement scheme, and the deadline for that is the 30th of June. So a lot of businesses were planning webinars and training and support to individuals in relation to that, and it's just worth bearing in mind not to forget about it amidst everything else that's on your plate. It could be easily forgotten. We are finding that there's a bit of a delay in relation to processing of these applications. There's problems with Home Office not having enough staff at the moment and people working remotely, so it's worth submitting applications sooner rather than later, as the backlog is only likely to grow as we get closer to the deadlines. There are also potential issues for third-party nationals who are family members of EU nationals. So what I mean by that is somebody, say, who's an American, so they're not a European national, and they are, say, married to a Spanish national. In many cases, those individuals actually can't have their application processed at the moment, because in many cases they need to submit biometrics and attend in basically a face-to-face appointment, which they can't do. So again, we're envisaging there might be a backlog in relation to their applications, and we could see some issues further down the line due to delays. The final point is that, as I mentioned at the beginning, post the 31st of December 2020, anybody coming in for the first time from Europe to work here is going to have to qualify under the new rules. And in most cases, employers are going to need to sponsor them under tier 2. So if you don't already have a sponsor license, and if you suspect you're still going to need European workers for certain medium and high skilled jobs, then I'd really recommend that you look into applying for a sponsorship license sooner rather than later. Again, we're seeing backlogs. So worth considering, even though I know there's 100 other things to consider at the moment, and that's probably understating it. So that's just a brief summary in relation to your European workers.
Thank you, Kerry. One question we've had from Angela Gildea. People who have joined our company who are to be relocated to London from Madrid but are not physically here yet, can they apply for settlement without being here in London yet? Now, I guess the question is, that's to do with the European the settlement scheme, I suppose, to do with Brexit, the European Nationals Settlement Scheme.
Yes. Yeah, I see the answer. Yeah, just come through as a yes.
Yeah.
It depends whether basically they were individuals who had already been living in the UK and have happened to go over to Madrid and have got stuck there because of COVID. And the likelihood is yes, then they can. If, see the answer, no. If they haven't actually entered the UK yet, then no, they can't apply under the EU settlement scheme. They basically have to have entered the UK, and they need to ensure that they do so before the 31st of December in order to then be able to apply, first of all, for what's called pre-settled status. And then after 5 years, they would apply for settled status. So unfortunately, no, they can't apply until they've actually come to live in the UK.
Thanks very much. And thank you very much for the question as well, Angela. I think that pretty much wraps up our webinar, unless anyone else has got any more questions to raise. Just giving it 1 minute, see if anything else comes through. I think that just leaves me to say thank you very much to all the panelists for your thoughts and insight into all these key issues for SMEs at the moment. But more importantly, thank you to all the attendees who've tuned in to listen to this on Zoom and on YouTube. And of course, thank you very much to Hannah and to the Spanish Chamber of Commerce in the UK for hosting us. If anyone has any queries they'd like to follow up with us on, please do get in touch with us. I think Hannah will share our details with you after this.
Yes, indeed, I will be. Thank you so much, Nick, and also Boma, Nassar, David, Helen, and Kerry. It was really, really interesting and insightful, everything that you covered in this morning's session. I will indeed, when I send out later this afternoon, a feedback survey about this morning's webinar, which would be really helpful if you could fill in. I will also be attaching the contact details for all of the panelists so that you can get in touch with any of them if you wish to. Thank you so much for joining us today, and everyone who's followed this webinar on YouTube as well. And please do keep an eye on the upcoming events section of the Spanish Chamber website for information about other webinars of this nature and others that we're carrying out over the coming few weeks as well. So thank you very much again, everyone from Stevens and Bolton, and yeah, see you soon.
Thank you very much.
Thanks.
Thanks.
Bye.